A federal judge in Massachusetts today found Donald Trump's executive order to reduce and control and limit, in many cases, and eliminate, in many cases, voting by mail is unconstitutional. U.S. District Court Judge Indira Talwani sided with Massachusetts Attorney General Andrea Campbell, 22 other states, and the District of Columbia, saying that Donald Trump, who casts mail-in votes himself, was interfering with states' mail voting systems. Judge Talwani wrote in her 37-page opinion, the Constitution does not grant the president any specific powers over elections, underlining the words does not. Judge Talwani continues, quote, the executive order attempts to intimidate local election officials to use the necessarily incomplete confirmed citizenship lists as a resource, lest they face criminal prosecution. Such efforts fall outside the president's Article 2 and otherwise delegated authority. No law enacted by Congress delegates authority to control mail-in voting to the United States Postal Service. These states alone determine voter eligibility requirements, subject only to the outer limits of the Constitution. Yesterday, a federal judge in Virginia said that a lawsuit filed against Donald Trump's $1.776 billion slush fund to pay criminals who attacked the Capitol on January 6th can proceed. U.S. District Judge Leonie Brinkema said that the Trump Justice Department officials were given the opportunity to end the lawsuit, writing, quote, on June 12, 2026, defendants were offered the opportunity to end this litigation by filing written declarations under the penalty of perjury, affirming that they will not take any action to create or operate the anti-weaponization fund, and that the fund will not proceed in any manner or under any other name. Instead of filing those declarations, defendants have filed a notice declining to provide such assurances under the penalty of perjury, claiming that such declarations are unnecessary and the compelled testimony of senior officials from the executive branch implicates serious separation of powers concerns. The judge continued, saying, on the record before this court, the President and Acting Attorney General Blanche's continued interest in compensating alleged victims of the alleged government weaponization, the defendant's unwillingness to provide declarations under the penalty of perjury, and the Acting Attorney General Blanche's refusal to rescind the May 18, 2026 memo, which set up the structure of the fund, all support conclusion that this civil action is not moot. Joining us now is Congressman Jamie Raskin of Maryland, the top Democrat on the House Judiciary Committee and a constitutional law professor. Let's begin with what seems like a pretty simple constitutional law question. How much control of elections does the Constitution grant to the President of the United States?
Zero, as Judge Talwani said. The Constitution vests that power in the states, and then there's complementary or supplementary power in Congress to alter the time, place, and manner of elections under certain conditions. But neither the states nor the Congress gave any power to the president to do it. So the federal court has properly ruled this was nothing but an outrageous power grab by the president, and he's got to stay in his lane. His job is to take care that the laws are faithfully executed, not rewritten and thwarted.
The states who got together and formed the United States of America by ratifying the Constitution would never have voted to ratify the Constitution if it said the president can control elections. They were already having elections in their states for their state governments.
Right. And when we, the people, created the Constitution, we were very clear that the president had no role in controlling congressional elections or, of course, presidential elections, which is why President Trump essentially had to apply all of that coercive leverage and pressure on Mike Pence to try to get him to engage in the political coup in 2020. And, of course, Pence stood up for the Constitution against the president. But that's another episode demonstrating that Donald Trump tries to interfere in a way that he has no constitutional place being involved in at all.
So we have a judge now basically allowing what will be a investigation of the Trump slush fund concept and possibly ongoing Trump slush fund plan. What can you do in Congress about it?
Well, we've got a discharge petition, and as you know, we've passed a number of discharge petitions. It used to be those things were extremely rare, but now we're governing by discharge petition because the Republicans can't do anything by themselves. But the Democrats, if we can get enough Republicans to come along with us, can stop nonsense like this. So we need 6 Republicans to join us in order to bring legislation to the floor to permanently stop the $1.776 billion political slush fund that Trump tried to deal to himself, as well as the permanent immunity that he tried to deal himself and his family and his businesses for not just criminal offenses. He got that basically from the Supreme Court, but for civil offenses as well, in the tax field and in all other fields. No federal department or agency can prosecute or investigate any of his crimes or civil violations under this self-dealing settlement that they made. So when we get back in, as soon as the Republicans can get their act together, at least to reopen Congress next week or the following week, who knows when they'll bring us back in, at that point, we are going to be pressing our discharge petition because, you know, Todd Blanche keeps saying we're not moving forward. Well, when my car comes to a stop sign, I'm not moving forward. But 5 seconds later, I'm moving forward. So we need to build this into the law.